Like, guys. Good afternoon. Thanks for joining today's Lunch and Learn. My name is Mike Kaparski. I direct CLEE's water program here at the Center for Law, Energy, and the Environment at UC Berkeley School of Law. CLEE is a policy research center, and at CLEE we help to link the expertise and creativity of the Berkeley law community into pragmatic policy solutions to environmental and energy challenges. We work with government, business, and the non-profit sector to generate innovative, interdisciplinary solutions to pressing environmental challenges. We draw on the combined expertise of faculty, staff, and students across UC Berkeley to translate research into smart public policy solutions that improve the governance of our environmental and energy systems. Through our Lunch and Learn series, we host conversations on a range of environmental topics, including unpacking complex and pressing policy issues and presenting new and innovative research findings. Our Lunch and Learn series is made possible through the support of our partners, Wilson Sonsini, Oric, and Hanson Bridget. Now, I'm delighted to introduce our speakers today. Tom Jorling served as minority counsel to the U.S. Senate Committee on Public Works, including the subcommittee on air and water pollution, which is the legislative institution where the Clean Water Act had its birth. Subsequently, Tom became responsible for implementation of the act as assistant administrator of US EPA, and later at the state level as commissioner of the New York State Department of Environmental Conservation. So through Tom, we get a front row seat on a retrospective look at the Clean Water Act. Dave Owen is professor of law at UC Hastings, as well as an advisory board member of CLEE. Dave teaches on environmental, water, land use, energy, and administrative law, and has conducted notable research in all of these areas, including on the subject of today's conversation. I can't think of a better person to talk with Tom on this topic, so I'm going to get out of the way. And Dave, Tom, thank you very much for being here. Looking forward to hearing this exchange.
So thank you, Mike, for that introduction. Thank you all for joining us today. And we're going to start out by talking a bit about the history of the Clean Water Act and then in its enactment, and then we'll move forward to talking about some of the implementation issues that have arisen over the years. And Tom, I wonder if you could start us out by setting the scene a little bit. Give us a sense of the political climate and the series of events that made it possible for there to be a Clean Water Act in 1972.
Well, there's sort of two aspects to that, Dave. One is sort of the social circumstances that we were experiencing at that time. It was not long after the upheaval of 1968. We still had Vietnam protesters in 1971, when most of the work was done on the Clean Water Act, occupying the Senate office buildings. And the senators actually found it rewarding to come and meet in markup sessions, closed markup sessions, because it gave them a respite from the constant interaction with protesters protesting the Vietnam War. So there was that dimension. But on the more substantive side, it was obvious in 1970, 71, that the water quality across the United States was continuing to deteriorate. And it was not only sort of by measurement of science, but by observation. And there were also several incidents that preceded that period, immediately preceded it, with oil spills, including the blowout at Santa Barbara in 1969. There were two other major oil spills in that same period. And of course, during the consideration of the Clean Air Act, which the committee had produced the year before in 1970, we had the more, I guess, media observation of concern with Earth Day in April of 1970. And among the things that Earth Day produced is it produced media attention. It was the first time, for instance, that Walter Cronkite devoted a few minutes a couple of times a week to some environmental issue. That did not exist prior to 1970, and that media attention had its effects. And then at the same time, you saw, and I don't know which is the chicken and which is the egg, but citizen activism started in a much different way than just the standard conservation lobby groups that existed at that time, like the garden clubs and National Wildlife Federation, Isaac Walton League were the only ones that existed. Well, in 1970, you had the development of Environmental Defense Fund, Natural Resources Defense Council. The Sierra Club developed a legal arm. So you had the beginnings of real citizen activism that began, and I would say they learned a great deal during the process of the Clean Air Act, and they had become much more sophisticated by the time the Clean Water Act was going through the process. So there were a wide range of forces that created the opportunity. And one of, I think, the more important ones were, in 1971, we had just completed shepherding the Clean Air Act through the process. President Nixon signed it on December 30, 1970, and he was under great pressure to veto it. And so we were very nervous about that. Fortunately, members of the committee and Bill Ruckelshaus had just come on board as the new administrator of the new EPA, lobbied very strongly with the president to sign the Clean Air Act, which it did. So we then, with the way Senator Muskie operated the committee, he would talk to the minority and the other majority members what was going to be the business of the committee in 1971, the beginning of the 92nd Congress, and it was to be water pollution. So we began the process almost immediately with the clean water, holding hearings. We actually held 33 days of hearings in the spring of 1971, late winter, spring of 1971. And part of the purpose of those hearings was to examine why the 5 federal statutes that had preceded that period weren't producing any results in cleaning up the water. What were the reasons? What was behind that failure? Was it structural in the statute? What was it? And so we did spend a lot of time in that period studying that question, and the Clean Water Act really is an answer to the questions that we learned. So that is sort of how we initiated it. It started right away we had our first public hearing in either February or March of 1971, and we knew, based on the experience of the Clean Air Act, we started that right away in the beginning of the 91st Congress, and it took the full 2 years to get to enactment. So we knew we were in for a long haul.
And can you tell the audience a little bit about where this was in your career, what your role was, and what your level of experience was as this process unfolded?
Upon graduation from law school, I wrote some very impassioned, idealistic letters to various federal agencies seeking position. And fortunately, 2 individuals, one Gary Hart and another one Gary Weatherford, who did have a career in conservation in California with the John Muir Foundation, I think it was. They found my background interesting. I had a master's degree in forest ecology and a law degree, and I sort of appealed to that background to a position in the Interior Department under Stuart Udall. Unfortunately, they found my background interesting, so I did start in the Interior Department. Went from there relatively quickly to the Smithsonian's counsel's office, and then an opportunity arose. Senator Cooper called me because another person of that same age had been asked by Senator Cooper earlier, and he couldn't take the position, so he recommended me. And I went up to Senator Cooper's office because I said to him, I grew up a Democrat, and I don't know whether that would be a problem. He insisted that it would not. And when I went into his office, and for the young folks on this, this reference will maybe need a little clarification, but everybody in his office were wearing Gene McCarthy buttons. All of his staff were wearing Gene McCarthy buttons. And so that sort of said, I guess they're right when they're saying that there's no partisanship, at least in among the members of the committee of the minority that served on the Public Works Committee. So it was an opportunity that I finally took. He took me around to meet other senators and assure me that it was a very bipartisan committee that was interested in producing public policy responses to issues. So it turned out I then left the Smithsonian and went to become the minority counsel for the Public Works Committee at age 28, I might add.
So can you tell us a little bit about the drafting process, what the day-to-day was like, and how it's different from the way that drafting processes typically might have occurred later on or today?
Well, the short answer is there is no legislative process today. And the drafting process starts with drafting bills that members would then introduce. And so that was the first sort of step in the process. Those bills, when introduced, would be referred to the parliamentarian, and the parliamentarian would then refer them to the Committee of Jurisdiction, which, if it was a water pollution bill, would come to the Public Works Committee. So that was the first step. After that, you began to sort of analyze the weaknesses in the earlier legislation, the flaws, I would characterize them as, and begin to try and draft language that would respond to those flaws. And that would basically be an exchange of memos. My colleague that represented Senator Muskie in the majority, his name was Leon Billings, he and I would sit down and we would write memo after memo after memo to the members of the committee. Certainly those memos went to the members before hearings, but then as we moved past the hearing stage and moving towards markup, they would actually in effect be a memo that would lay out some principles or some ideas that should be incorporated into new legislation. Once the committee moved to the markup sessions, you would actually draft what we called committee prints. And I might add the real heroes of that process, because it was long before the electronic revolution. Each committee had an employee of the government printing office. And so Leon and I would sit down with that person and we would craft language. That person would take that language overnight and a bill would be produced, a committee print bill in bill text, which is the lined, numbered lines and large print, quadruple spaced kind of thing. And we would have that the next morning. So that became sort of the most important steps, because as it became clear, and Leon would always say, he who writes the first draft controls the process. And so that was an important set of steps, that production of a bill, and accompanying that with memos that would explain to the members what the purpose of that language was and how it was and why it was incorporated into the committee print. So once you get to the committee print, each markup would produce multiple changes and also additions, very rarely subtractions, but a lot of ideas for addition. And so you would sit down with that printing clerk again and go through that again and prepare another committee print. I think on the Clean Water Act, before the bill was actually reported from the committee, we went through something like 25 committee prints. And in succession. And so it was an interactive process. You crafted the language, you wrote it, and you tried to understand what it was trying to achieve, what problems it was trying to solve, and articulate that in either oral remarks at the beginning of each of the markup sessions or in memoranda. So it was an interactive process, and one that the committee members took seriously, and they would ask very difficult questions. We can go further into sort of the dynamics of the members and how they operated, but from a committee staff perspective, it was crafting language, trying to explain that language, why and what it was trying to achieve, getting a reaction, and then modifying it as the committee members directed.
And so if you're listening, one thing you might be thinking is, wow, that sounds like a really big role for a legislative staffer. And I'm just going to share with you, if you search Westlaw for Jorling, you actually come up with a lot of hits, and a lot of them are talking about the distinctive role that Tom and that Leon Billings played. And I'm just going to read for the audience a couple passages from law review articles. So the first one is from an article by Bill Rogers, who taught for many years at the University of Washington. Just a quick quote. Section 301 of the Clean Water Act was a central page in the distinguished career of Senator Ed Muskie, with the staff heroics accomplished by Leon Billings and Tom Jorling. And then this is another one. This is about the Clean Air Act, not the Clean Water Act, but it conveys the same basic point. This is from an article, recent article by Brigham Daniels and several co-authors about the making of the Clean Air Act. He says the roles that Leon Billings and Tom Jorling played on the committee were also significant. They were not only the work engines that translated the subcommittee's deliberations into concise statutory language and organized the agenda, they were also active participants at critical decision points, at times even being advocates for policy positions, generally granted considerable deference by full members of subcommittee. And so I think that gives you a sense of in addition to this, that the story Tom tells is accurate, and the level of influence that he played, and a level of influence that young lawyers don't typically get. So Tom, just you mentioned personalities, and I wonder if you could tell us a little bit about that. And I wonder if you can also just say a little bit, this is a less substantive question, describe like the places where these bills were actually get written, the rooms or perhaps the trucks.
Okay, I'll start with the basic committee conference room is a room off of the hearing room. It's a small conference room, a classic table of a conference room with the majority chairman sitting at the head of the table, and then the majority arrayed one side and the minority down the other side, seated as they rank in the Senate. So the most senior members would be closer to the head of the table, the more junior members further along the sides. And it was a period, and there are two distinctive characteristics. One is it was a period when all of the members of the Senate at that time were males. And the other characteristic that they all shared was they were all smokers. And there was no areas in the Senate where smoking was prohibited. So during the course of a meeting, several of the members were chain smokers. That room would become very uncomfortable, especially for those of us that were non-smokers, which was, I might add, a minority of one. But the room also, on the other side, facilitated close interaction and dialogue between and among the senators. And so there was an opportunity in a closed markup. And I could say that, for instance, one of the major changes, which I think was disastrous of the reform movement of the 80s and 90s, was to open up markups. Because when they became open, every member of the Senate had to first decide, how is my statement going to be received by my base or by the lobbyists? When they were in this other character of a closed markup, they could let their hair down and they could ask, as Senator Baker would often precede his question, he said, this is probably a stupid question, but what? You couldn't do that in open session. But in markup, he would do that. And Muskie would often take the position of the other in discussions with Leon and I. If we had advocated some kind of a position, he would take the position of an industrial lobbyist, in effect, and press us as to how that provision would operate, and test it very thoroughly, and sometimes very angrily and aggressively, so that if you had an open session, he couldn't act like that. He couldn't show any emotion and express any displeasure with either another member of the Senate or certainly with Leon or I. So it was a very good opportunity to engage them intellectually. And Senator Baker often has written and said, we enjoyed that. We, the senators, enjoyed that interaction. We learned from each other. We understood where each other was coming from. We could figure out solutions to one or another of the members' problems, and we could work through to a consensus. So it was it was a very intense period and a very intense process, but it was one that produced, I think, both in the Clean Air Act and in the Clean Water Act, terrific outcomes.
And can you tell us about the truck?
The truck. Well, not only was the crafting that we did for the preparation for these markup meetings, but Leon and I happened to both live in Silver Spring outside of Washington, D.C., and we commuted together in Leon's Ford 150 truck. Leon he couldn't shake entirely his Montana background and upbringing. So we would ride back and forth. There was a little package store right at the beginning of North Capitol Street, which we would pull off and go in and get a 6-pack to help us get the rest of the way home. So often it was said that we actually crafted the language in that truck. And there's some truth to that, because both of us had dictaphones, and we would dictate either a memo or language for the next committee print in that ride home, because it was an opportunity we had of really good, focused, quiet time away from the phones and away from, this was long before cell phones. And we did accomplish a great deal. My wife tells the story that one time we had some ideas apparently that were burning, and so my house was first. So we went into the house, cleared off the dining room table, and we sat down and marked up a committee print with what we had concluded on the ride home. So the truck was a very important part of the process.
So I'm going to work in some audience questions as we go, as well as continuing to ask my questions. One of the questions that's come up in the chat is, in 1970, Joe Sachs, who was a professor at Michigan at the time and then later at Berkeley, published an article about the public trust doctrine. And I'm wondering, the question is whether Joe Sachs's ideas about the public trust doctrine influenced your thinking as you were developing the Clean Water Act.
Actually, I think another article that Joe had written was more influential, and it was, if I can sort of recall some of the elements of it, but he was advocating basically access to the courts to develop a common law of environmental pollution. And that article had a great deal of influence in this sense. Muskie's closest friend in the Senate was Senator Hart from Michigan, and Joe Sachs was close to Senator Hart. And so Muskie says, is there something, I don't like that concept of a common law of environment. We're never going to get sufficient controls on industry if it's developed one by one by one. So he said, but we've got to give Phil Hart, was his name, we got to give Phil something. And so I received direction to see if I could take something of access to the federal courts and craft something that would be, we could say, had some roots with Senator Hart. And that ultimately became the citizen suit provision in the Clean Air Act, and also carried over into the Clean Water Act and several other statutes later enacted. So that was, I think, there are elements of public trust in that, but that was the position that I think Joe Sachs had great influence. And you mentioned Bill Rogers. He also had influence because he wrote an article advocating the use of the Refuse Act of 1899 as a vehicle to control dischargers into navigable waters. That ultimately had significant impact on the evolution of Section 402, the permit program. And it also influenced greatly the staff of the Council on Environmental Quality, which had just come into being as part of the National Environmental Policy Act. And Russell Train was the first chairman of that, and he brought in some really aggressive young lawyers, among them Bill Riley, another one, Boyd Gibbons, Tim Atkinson, and they seized on Bill Rogers' article and developed a permit program that the administration actually issued by presidential executive order. So that had a great influence on how the basic regulatory structure of the act works, but it needed some, I guess, details that were important. One of which is the prohibition of a discharge without a permit, and then the permit program really had teeth. So that was all part of our learning in the hearing process and searching out ideas, which Leon and I did. And we also visited California. I think on 3 different occasions, we would fly out to California to meet with the Water Resources Board, because California and a few other states, I would name Michigan, Minnesota, Washington, and New York as states that had advanced water pollution programs. And they were actually far in advance of the federal agency at that time, both in capacity and knowledge. So we would visit the states. We also visited some of the contrary states. We went to Texas, and Texas chairman of the Water Resources Board refused to shake our hands because we were from the federal government, and we don't want the federal government in Texas. So it gives you a sense of the distribution of how the state's attitudes were at that time, and in some respects continue. But it was those law review articles and their testimony, both Bill and Joe testified to the committee, were very important.
So I'm going to take us fast forward for a moment, and we'll go back again. But we're now 50 years after the passage of the statute. What's your overall assessment looking back? How do you think this bill that you did so much to craft has performed?
Well, part of my answer is informed by my own observation of water quality at the time. I grew up in Cincinnati, Ohio, and the first thing any parent would tell a child was, don't go anywhere near the river, because it was a place where you could not be without getting sick. So if you look around the country, Leon and I said if we could get a nickel for the increase in property values of waterfront property that has been produced by implementation of the Clean Water Act, we would be gazillionaires. And there's some truth to that. I do spend now time in Boston, and Boston Harbor at that time was a sacrifice area. The area near the waterfront was derelict and run down. Now it is the most prized real estate in Boston. And almost every waterfront community has experienced that same renovation or upgrade. So in general, I think the act has produced very well. There's some aspects of it that am disappointed in, one which probably nobody ever pays much attention to, but we had a provision in the construction grant part of the act that communities had to develop user charges that would then create a corpus of resources for operation, maintenance, and replacement. And the local political establishments have been unsuccessful in implementing that provision. And so they have to continue to rely on some kind of federal assistance, now assistance provided through the state revolving funds. But the fact that we did not accomplish sort of charging citizens the costs of keeping their nest clean has been a disappointment. But by and large, I think with some changes that came in the 77 amendments, primarily codification of the Flannery Decree, which was a settlement produced by an NRDC lawsuit that then gave us a much better handle on toxic releases. So I think as a general matter, and the condition of the waterways of the U.S. reflect it, it has been a huge success.
So when we talk about what the Clean Water Act has done, where it's been effective and where it is not, on the where it has not side, the conversation usually circles pretty quickly to regulation of agricultural pollution, and also to the exemption of agricultural stormwater runoff and return flows from irrigated agriculture from the definition of point sources. And I wonder if you can tell us a little bit about the early history of the Clean Water Act and ag. Is this something that was a focus of discussion in 1972 when you were initially crafting the statute? And perhaps you could also shed, if you can, some light on what happened between 1972 and then 1977 when those exemptions were written into the statute, and what Congress's plan or what its thinking was.
Well, I think the honest answer is a couple of aspects to an honest answer. One is, as hard as we came up with innovative or creative ideas, we couldn't come up with a vehicle with federal leverage over non-point sources. We resorted to language in Section 208 that directs the states to develop best management practices for activities that produce runoff, agriculture, forestry, construction. And in some respects, those have had some considerable success. Setbacks from streams before you could plow, and then different no-tilling agriculture, those kinds of things are all part of the best management practices. But I know as I look at a lot of the criticisms that people direct at the failure, I guess we'll call it, I wouldn't quite call it a failure. I'd call it more an inability to address non-point sources. I haven't seen any that propose something that could get enacted. What is the language you would use to create a program to regulate non-point sources? And now getting back to your real question is, what was the role of agriculture? Sort of Bob Dole served as the agricultural interest representatives on the committee, and he would explain how difficult it was for farmers and for farmers to respond to mandates, if we call them that, because they were operating on such thin margins now. So it needed some kind of largesse from the federal government. And so we would basically say, these are appropriate matters for the Ag Committee and for the conservation bills that they write. And there's been some of that subsequent. There wasn't any at that time. But that was it. I can tell you, Leon and I failed as hard as we tried to come up with some way of regulating non-point sources, we couldn't come up with them. We were also informed by the early experience in the Clean Air Act, which was with transportation controls, which is a similar kind of issue. How can you come up with a regulatory scheme that affects citizens as opposed to institutions? And as you probably know, the Clean Air Act failed with transportation controls by the EPA trying to write a program for Los Angeles, which limited the number of days a person could drive and the number of places a person could park, and it just broke down. When you get down to that level of individual citizens, we don't have really good vehicles to change behavior. So it was part of that. We just couldn't come up with a meaningful vehicle. There were other issues like agriculture, mine runoff, surface mine runoff. Every time it rains, wherever there's been a surface mine, a tremendous amount of pollutants, primarily acids and sediments, run off of those sites. And the question was, how do you regulate that? And we couldn't come up with one. The Surface Mine Act, which Senator Baker was instrumental in passing through the Interior Committee, the Commerce Committee, attempted to do that, but it's still inadequate. So it's an area where there's still conceptual problems as well as sort of drafting problems and just generally regulatory problem. And I still haven't seen anybody recommend something that would work.
So in the chat, we've got a couple Sackett questions, and I'm going to combine them a little bit and simplify them to say, first off, did you anticipate that challenges like Sackett were coming? And second, is this a kind of litigation that you foresaw when the act was first being drafted, that there would be questions about what the scope of waters of the United States is? And second, I'm curious if you have an opinion about what outcome of that case would be most consistent with the intent of the Clean Water Act's enactors from 1972 or 1977.
We were very aware that waters of the United States was going to be a definition that was going to be litigated. Our objective was to extend the reach of the federal government over water as close to the hydrologic cycle as we could get. That was our objective, because we recognized that materials reach surface waters through a whole variety of pathways. And so we wanted to have that as our objective. And one of the things that Leon and I would do every time there was a Supreme Court decision dealing with either the Clean Air Act or the Clean Water Act, we would get in touch with each other and we'd say, what grade do you think they gave us? When I must say, I get blurry between the Ramaphosa decision and the Swansea decision. But when the first came down, we breathed a sigh of relief. We thought that we were vulnerable. If you look at the history of the definition of navigable waters and then interstate navigable waters and then waters of the United States, that there was a significant chance that CLEE would limit it back to interstate navigable waters, which is about 40% of the surface waters of the United States. So when we got by that, we felt very good. When you get now to the more recent challenges to the definition, I think we felt very good that the Kennedy, was it a concurring opinion, I think, where he came up with this idea of a significant nexus, was a good, reasonable solution to the ambiguity of the term. And then what the Sackett's decision is going to do, I didn't listen to the decision, the argument, but it sounds like from some accounts that I've read, that there's an expectation they'll further narrow the definition, that the conservative majority will further narrow the decision. Although I sort of, not altogether facetiously ask, is there a lawyer out there that would tell a manufacturing entity that they could put an outfall pipe into one of these contested wetlands without a 402 permit? I don't think so. So if it's jurisdictional for 402, it should be jurisdictional for 404. But it's a tough area, and I don't know. I guess given the composition of the court right now, I suspect it'll be a more difficult decision than I would hope.
And I'm going to back up for a second. For those of you who are not Clean Water Act wonks, the question we're talking about here is the geographic scope of the statute's coverage. And so there's a question, does it extend to intermittent streams? Does it extend to seasonal wetlands? Does it extend to wetlands that are somewhat nearby a larger water body but don't have a surface connection to that water body? So there's a lot of smaller or more ephemeral or intermittent waterways. And the question is, does the act extend to those? And Sackett is the most recent case to address this issue. An oral argument took place early last Monday, not this week's Monday, but a week and a half ago. I did listen to the argument. It was not quite what I expected. Justice Kavanaugh seemed very skeptical of the Sackett's position, and Justice Barrett did as well, which means that, well, it's oral argument. It really doesn't mean much. It's hard to tell, but it suggested that this case might not break down along the traditional 6-3 lines. So I wanted to follow up on that.
Let me interject there. One commenter I was talking to said, well, maybe we're going to be lucky and be treated with a victory because the Supreme Court is so concerned about its reputation, and they want to give the other side one for the Gipper, as it were, and they'll come out with a favorable decision. I don't know. They're pretty strong in their opinions.
Yeah, I would agree with that. So I want to follow up on one, because this is the question I've always wanted to get a chance to ask. Because in the Clean Water Act, with the definition of waters of the United States, you started with a term that had one traditional meaning, navigable waters, and then you defined it to mean what looks to me like something quite different. And this happened a bunch in drafting in this era. It happened with the Resource Conservation and Recovery Act, which defines solid waste to include liquids and gaseous wastes. Happened with the Endangered Species Act. And this may be too fine-grained of a question, but I'm curious, was there just an acceptance that you would start with a traditional and familiar term and then rework it over the course of legislative drafting? Or what was behind those choices?
Well, I think the first step in that sort of progression of logic was that the traditional definition of earlier statutes, interstate navigable waters, was very limiting, and a lot of waters didn't reach that definition, and so we needed to push beyond that. And then the question is what underpinning in the Constitution and in sort of practice is available for extending the federal reach into further upstream, I guess we'll say it for shorthand. And we knew it was important, if we were going to adequately control water pollution, that we had to reach exposures to water or releases to water that the earlier definitions did not reach. And so we knew that when we were trying to create that definition, waters of the United States, that we were going to be challenged on that. But it was really an effort to reach further to the sources of release that are causing pollution. And that was our objective. And we'll find out again whether we succeeded in that. It's not just a wetlands issue, although that's way the current description of the issue is. It's also a pathway for pollutants to reach surface waters, and that was what we were trying to get at.
So let me ask a somewhat different question, although this I think relates to the Sackett case as well. Can you talk about your vision in 1972 for how states would be involved in Clean Water Act implementation? Were ideas of federalism important at that time and during the drafting? And what were the ideas? If they were important, what were the ideas of federalism that you were trying to pursue?
Well, the first part of that answer is Muskie was a governor, and Muskie was chairman of the Intergovernmental Relations Committee in the Senate. And he had strong feelings about the role of states and the importance of that role. He certainly wanted the states to be free, to be more stringent than anything the federal government did. He was insistent on that principle. He wanted to make sure that a state could go more stringent than anything the federal statutes would require. So that's codified in the 72 Act. Then the question came that this program is going to require significant administration resources. And it's unlikely that the federal government will ever develop that capacity. So that the federalism that is there was, for instance, the 402 permit program. If the state could show that it has equal authority and capacity to implement the permit program, then it could be delegated to the state to administer. And that is, however, backed still by a bit of an override or a veto power that the feds have. But it was a question. I know we developed figures at that time, and I can't remember them, but we added up all the state resources, personnel, and dollars in all of the water pollution programs across all the states. And it was many multiples of what the federal government had. And so we knew that we had to somehow take advantage of that resource. And you did have, too, our experience, which I mentioned earlier. There were some states that were much more competent than the federal government was at that time in water pollution control. I just was meeting with Ron Roby and Bill Dendy when I was visiting the coast, and we were chatting about the conversations that Leon and I would have with the state of California and compare those to the conversations we would have with the staff of the Water Pollution Control Agency in the federal government. And it was so far superior in sort of the approach. The approach was much more science-based, much more technologically advanced. And so we respected that, and we didn't want to jeopardize certainly the good states from implementing their program and implementing whatever federal program they could. So it was partly Muskie and other members of the committee feeling that the states needed to have a role. It was partly recognition that the federal government would never have the resources. And it's curious, for instance, Massachusetts chose not to receive delegation on anything. They let the federal government implement the program in that state. And they did it primarily because they didn't have the resources to do it. So we did not assume, I guess, in short, that all capability and knowledge resided in the federal government, and that if you could get a state to qualify with demonstration that they had the authority, they had the capacity, then we could delegate with reasonable comfort. And I think my experience in New York State was, thank goodness we did, because New York went much further than the feds were requiring us to go. And we had much more capacity to deal with things than they did.
So we've got about 9 minutes left, and if you have a question, I would encourage you to put it in the chat or the Q&A. But otherwise, I will keep going. And I wonder, just following up on this conversation, this may be getting into the weeds a little bit, but another major recent source of controversy has been Section 401 of the Clean Water Act, which gives the states basically some leverage over federal permitting. And it's one of a couple provisions in the statute that actually give, in a sense, give the state the final word. And I wonder if you could talk a little bit about the thinking behind those provisions. Were they seen as major parts of the act, and what was the goal of adding them in?
Section 401 comes out of the Water Quality Improvement Act of 1970, where the certification program was first enacted. We refined it considerably in Section 401, but it was an attitude that the states should have, in effect, veto power over federal projects if and actually almost any project, but federal projects were one of the primary ones. That if the Federal Power Commission wanted to put in a dam, a state could prevent that on water quality grounds if it chose to. And again, that was a position that Muskie felt strongly about. He was concerned about some dams that were going to be built in Maine, and the federal government basically coming in with a heavy boot and insisting that the federal government overrode the state opposition. So it was a strong feeling, and it was shared by many of the Republican members, that if a state couldn't certify a project on water quality grounds, that project shouldn't go forward. If that was the state's choice, and so it was intended to be of that significance or of that power. It's now becoming more important because of its use. Some states are choosing not to certify on water quality grounds, but it was a continuation of that same view on federalism, that the federal government could not override a state if it had an objection on water quality grounds.
So
one of the things I was going to say that really does hit, I suspect, in the West right now with the water shortages that are occurring, and what the federal government's likely to start coming in with. And I know, based on my experience from the Public Works Committee, we had the Civil Works Subcommittee, which had the Corps of Engineers, and they had a program called NWAPA, ready to go. And this was a I don't know, maybe 7 or 8 volumes of plan to tie all the water systems of the U.S. together into one manageable system. And it started with a reservoir in Alaska that would then be created to bring water down to the Northwest and California. And they were going to excavate that reservoir with nuclear weapons. So the engineers have solutions to the problems, but it'll be interesting because everybody now is starting to look at the Great Lakes with great envy, and the Great Lakes states are not about ready to let any of that water go.
So there's a question in the chat that is actually directed at me that I'll start answering, but then Tom, I'm going to turn it into a question for you. So the question was, how should a professor factor this sort of legislative history into teaching law students today? And how relevant is this for training lawyers? So Tom, the question I'm gonna briefly respond, but then the question for you is, how do you think this should be relevant? Like, how do you think we should be incorporating the kinds of stories and history that you're providing into our teaching? And so my own answer is, It is a little bit tricky because we're teaching students to interpret statutes, and the courts have become increasingly skeptical of legislative history as an interpretive tool. And so teaching students that the answers to whatever statutory question you're confronting are to be found in the legislative history is not good preparation for the practice of lawyering today. So I think it does have value because it can help you spot issues, it can help you understand context, it can help you make sense of statutes, and there's more to law than litigating. And so it can help you learn for future legislative efforts. And then lastly, of course, it's not like all judges are categorically rejecting legislative history. Some are still interested in considering it, and if you're in their court, you need to know it. But let's make it a question for you. What do you think we should, a law student today should take from the historical stories that you've been able to tell us today?
Well, that's a neat question. The first is a little bit more history. In that era that these statutes were written, the 70s, legislative history was significant. It was before CLEE sort of began to dump cold water on it. But we had a different orientation, and this gets into another piece of the importance of, we haven't talked much about the House of Representatives. Our approach in the Senate, driven by our members, was we want to say what we want to have happen. We want it clear. The House of Representatives had the opposite philosophy. It was, we'll write ambiguous language and let the courts sort it out. That was their affirmative approach, because they couldn't often get votes in committees to write specific legislation, clear, unambiguous legislation. So where they would run into a problem, they would complexify it, if that's a word, and hope then they would write legislative history, which the staff would control in the report, the committee reports and the conference report, which would hopefully guide the court to their answer. So there was a very distinct philosophical difference between the Senate and the House. And that was more general than just our two committees. The House Committee on Interstate and Foreign Commerce in the Clean Air Act, they wanted to make it so ambiguous that all questions would go to the courts. So now back to the question, is it important? It is important to teach the legislative process in law schools. And it's also important to teach crafting language. The most important course in law school that I took that bore on my work as a drafter was contracts, because there is emphasis on precision in language. So Leon and I would sort of test sometimes. We would write a provision, especially in a controversial area, and then give it to 10 different staff members and say, what does this say? And if you got 10 different answers, you fail. If you got only 9, you got 9 people saying it meant the same thing, you were getting successful. In contracts, for instance, I remember a professor, when a person would get up to recite a case, he'd say, if that person made the mistake and said more or less, he would always interrupt and say, well, which is it, more or less? It can't be both. So language is exceedingly important in crafting statutes. And so whatever, in preparing students, how to read language, how to understand where the vulnerabilities in language are. I mean, the simple things that we attempted to do. We removed discretion as every place we could. We wanted to change the word may to shall, to make it mandatory that that administrator had to promulgate a regulation by a certain date. And if they didn't, the citizen supervision was available to compel it. And as it turns out, that was very important because when I was at EPA, and if I went over to OMB and said, I've got this program that I've got to implement, the first question they'd say, what if you don't do it? And I'd say, well, I've already got a court order saying I have to do it. If I could say that I had a court order to do it at OMB, I got the resources to do it. If it was something that was discretionary, they'd say, sorry, we don't have the resources for that. Defer that. So language is very important. And I think, law school generally emphasizes language. But even if the courts don't use legislative history in the standard formulaic way we used to and were taught in law school, the author of the bill and the Senate report and down that chain of importance was important in interpreting statute. Even if that is certainly less applied, it's important in understanding language. And I think that's where I would put my emphasis.
So we are at the end of the hour. Thank you all, audience, for joining us. Thank you, Tom, so much for sharing your wisdom and for the work you did over these many years. And hope to see you at future Lunch and Learns.
All right, thank you very much, and thank the students.
Tom, Dave, on behalf of CLEE, we really appreciate your sharing your time and insights. This was extraordinarily interesting and engaging. I know I speak for the audience members as well. For everybody on the call, thank you for participating. Please, if you aren't already, follow us on Twitter, sign up for our email updates for more notices of events like these and the broad range of research products and events that we will continue to produce. Goodbye. Have a wonderful afternoon. All the best.
Thanks, Mike. Thanks, Dave.
Thank you both.
Kiki's closing us out.
Thanks.